Thank you very much. It's really a pleasure. I'm really grateful to be here today to try to go on review of the several case law that I have identified, which should be or could be called as breaches or opportunities of breach of the unitary character of the trademark. I don't know, first, it might be good to go through there we are, through the general dispositions or regulations. As you know, Regulation 2017-1001 says that the European trademark shall have unitary character. It shall have equal effect throughout the Union. It shall not be registered, transferred, or surrendered, neither be revoked, declared invalid, nor shall be prohibited, save in respect of the whole Union. However, this principle shall apply unless other provisions provided by the regulation. So this states the general concept of the unitary character of the European trademark and who should live along or which should live along with the national trademarks. This unitary character means that any application for register is gained at the whole territory of the European Union, and therefore that if there's a refusal, the denial may be valid for any member state where the opposite protected brand was earlier registered, for the whole European Union as well, and even for member states who didn't have any objection. Regarding this unitary character, Article 1.2 of European Union Trademark Regulation sets some exceptions, save in respect of the whole Union, and therefore it relativizes the unitary character, for instance, regarding or recognizing the particular or the local rights, as well as the possibility of claiming for infringement against this European trademark registered. Further consequences of this principle of unitary character is that the European trademark is ruled or subject primarily to European law and secondarily to member states' law, especially in the terms of infringement. The infringement is regulated by national law, as is stated in Chapter 10 of the European Union Trademark Regulation. Both the European trademark and the national trademark should live along. Therefore, the proprietors or the owners of national trademarks should give notice of opposition, could claim for invalidity, and could prohibit the use of the European trademark. However, this has two offsets. The first, the consent and revocation, which is in Article 58 of the European Trademark Regulation, and on the other side, the obligation of genuine use of Article 18. And thirdly, there are some exchanges between the national and the European trademarks. For instance, the possibility of claiming for a European trademark based on the seniority of an early national mark, Article 39, or to convert the European trademark application into a national application, but with a hint of seniority coming from the national trademark. The unitary character also implies that whenever there is a doubt on the national registration level, for instance, if it's found that the brand to be inscribed could be descriptive of it has not been used seriously, in that case the registration should not take place, to give or leave a space open for European trademark. It also entails the possibility to prosecute Europe-wide counterfeiting acts and the possibility of issuing orders prohibiting the infringement. Regarding the case law, I would like to review. I would rather say that I will serve on these 7 cases. First one is the Limoncello case. This case is important because is the fight between the registration by Sacca di Laudato of this figurative complex mark, Limoncello della Costiera Amalfitana, against the registered word brand Limoncello in Spain. The most important thing of this case is that at first the General Court decided that there was a dominant element, which was the figurative representation, and therefore this figurative representation was dominant. There was no likelihood of confusion. However, this was annulled by the Court of Justice in a judgment in 2007, saying that there shouldn't be a singular or a specific element to be taken, and that should be the court should have done an overall analysis or examined the mark as a whole. Then the case went back to the General Court, and it's there where the General Court remembered the case law in Matratzen, in which the validity of a national trademark could not be called into question in proceedings of registration, but only in cancellation procedures. And it concluded that the limoncello element, the verbal element, was the element to be compared, and it had sufficient distinctive character, and therefore they found that there was no likelihood of confusion. The following case law is the case law Formula One. In this case, Racing Life tried to register the F1-Life as a figurative complex mark with two verbal elements against three word marks. One was international, another one was German, another one was UK. It was taken for the examination at the General Court, the international mark, as well as the figurative mark. Regarding the international mark, first, what the court stated was that it didn't have distinctive character, and therefore it was descriptive of the racing sport. In fact, it said F1 in ordinary typeset had a weak distinctive character, and it was descriptive of car racing. Formula One, F1 Formula One, which is the other figurative element down, had a certain reputation. However, there was a lack of visual similarity and a limited phonetic and conceptual similarity, and it concluded that there was no likelihood of confusion. This was challenged before the court, and the court definitely said that in opposition proceedings it's not possible to find that a sign or a trademark protected in a member state has an absolute ground for refusal and lack of distinctive character. It cannot be stated that it's descriptive of generic. Finally, it concluded that the General Court declared that there was no distinctiveness and set aside this judgment, concluding that the F1 element, word element, and the F1 logo had a certain degree of similarity, visual, phonetically, and conceptually. Even if the distinctive character of the earlier mark F1 is weak, that does not preclude the finding that in certain circumstances there might be likelihood of confusion. Although the distinctive character of the earlier mark must be taken into account when assessing the likelihood of confusion, is not the only factor. Even an earlier mark with weak distinctive character may have a likelihood of confusion of similarity with signs, and therefore the comparison should be done not only regarding the sign, but also regarding the goods. The following judgment, these two judgments are very interesting because it's a kind of annulment by the General Court, by the Court of Justice, because of the appreciation of the General Court either didn't take the specific element or declared that some specific element was dominant when it was not, or either it denied the distinctive character of a national brand. The following case is the DHL case. I think is relatively known by everyone. Is interesting because it's a case in which a provision of infringement implying coercive measures such as periodic penalty imposed by a community trademark court in France, the appeal court and the court of first instance of Paris acting as a trademark court. And these orders, it should be considered whether these orders have an EU aspect and should be valid all through the European Union. In this case, it settled the principle, the Court of Justice settled the principle that to analyze the effects on the entire European Union throughout all the member states of community trademark, it should be taken into consideration the competence of the court, or its territorial jurisdiction, and the extent of the proprietor's rights and the territorial extension of the right of the proprietor, who is entitled to protect his interest and should also protect those interests in the scope of the functions of the trademark, which is in principle to be applied all through the European Union. It stated as final conclusion that the interpretation of Article 98 of the regulation on the trademark must be interpreted that when a coercive measure such as a periodic penalty payment is ordered by a community trademark court by application of national law, in this case the French law, in order to ensure the compliance with the prohibition against further infringement of threat of infringement, this has effects through all the member states other than the member state of the court, other than France. There should be a recognition and enforcement of judgments at the national court and also in the other member states. And if they don't have such a measure, they should attain the objective in an equivalent manner as they have in the French system. The following two cases are the most interesting from the point of view of the scope. The Commit is a case in which Commit business tries to register, is using Commit through the internet, and Commit goes before the German court asking for an order of prohibition of using this product. From a double scope, it goes first asking for application of the German regulation and also to apply the European trademark regulation. The Oberlandesgericht Düsseldorf, who is the court who raises the preliminary ruling before the European Court of Justice, finally stated in the application of the European trademark regulation that there could be a likelihood of confusion of Commit and Combit before the German-speaking public, but not before the English-speaking public, and therefore there was not conceptual similarity between those two brands, and then the phonetic similarity could be reduced. What's the importance of this case is that the European Trademark Court is declaring that the use of a sign Commit may create likelihood of confusion in part of the European Union, but not in another part, is the infringement or the order prohibiting enforceable Europe-wide. The conclusion is obviously that regarding the principles of the DHL, in which it gives the possibility that a similar sign does not give likelihood of confusion for linguistic reasons, there could be a limitation of the territorial scope of the prohibition, and therefore that the approach of the Oberlandesgericht Düsseldorf saying that regarding the English-speaking public, even Europe-wide, there was no likelihood of confusion, is valid for the whole European Union. The following judgment that I would like to go through is the Kerrygold-Kerry-Made. This judgment is also relatively interesting regarding that is a case in which there is a case of peaceful coexistence between the trademarks Kerrygold and those two figurative marks plus the European trademark Kerrygold, and there is a use of the Kerry-Made for margarines in Spain for import and export of margarines in Spain. The question is whether this peaceful coexistence will exclude the likelihood of confusion between those two marks. The first conclusion that was stated by the court is that the fact that in part of the European Union, UK and Ireland, the European trademark and the sign at issue have peacefully coexisted is that it doesn't imply that there will not be a risk of confusion. Further, the second biggest question or issue raised is whether the geographic, demographic, or economic contents or elements in UK and Ireland, which is the territory of the peaceful coexistence, could exclude the likelihood of confusion in other territory of Spain. In principle, it stated in the second question, the court stated a very important declaration for assessing whether Kerrygold could prohibit Kerry-Made in Spain. There are elements present in Ireland and UK that it should be first of all ensured that there is no significant difference between the market conditions and sociocultural circumstances which may be observed in Spain and in United Kingdom and Ireland. And as well, the use of the sign could follow honest practices in industrial or commercial matters, and it should be analyzed differently in the case of the country where there is a particular affinity with the geographical word, which is UK and Ireland because of the term Kerry, in comparison to Spain. Finally, it concluded regarding the third question that the pacific or peaceful coexistence of both marks could, in any case, be considered a due cause for legitimizing the use of carry-made in Spain. Then the following judgment is related to designs and mark, but the designs of community designs, and is regulated by Regulation 6/2002. It's very interesting because there are three statements. One regarding the supplementary claims, which are the claims that took place. Well, in this case, is the fight between Nintendo against Big Ben, who is distributing let's say, remote control accessories which are compatible with the Wii in the chain of supply, and therefore it relates to the extent of the order of prohibition issued by a German court. In this case, regarding what is the supplementary claims, the provisions on the information accounts and documents, order to pay compensations, destruction and recall of goods, reimbursement of the lawyer fees, publication of the judgments, the court considers that they are in the same situation of law, and therefore that they should be under regulation, which is, from my point of view, something that is not strictly orthodox and will open a lot of space for conflicts regarding these fora. Further, regarding the other questions that are treated regarding international jurisdiction, the most interesting things are the ones that settle in the cases to be determined where the infringement has been committed according to the Rome regulation, which is Regulation 864. There are two different criteria. Article 8.2 of the Rome regulation considers the competence of the court for non-contractual obligations where the infringement has committed. However, Article 4.1 of the Rome regulation states that it should be taken where the damage occurs. How these two clauses or articles are compatibilized is settled by the court. But what is most interesting is that the court says for analyzing in cases of various infringements, where does the event giving rise to the damage take place, and therefore what the competent court is, it should be taken an overall assessment of the defendant's conduct. And this, from my point of view, it really leaves an open space for new criteria. The same happens when it deals with the analysis of goods that have been allegedly infringing the rights of the protected community design, which are shipped by third-party undertakings to other member states than the one in which the applicant is domiciled. It also leaves or states the criteria of making an overall assessment of the defendant's conduct to determine where the initial act of infringement took place, and this leaves a lot of space open. However, it really settles a certain rule regarding the operations on the websites and the sales which take place online, that states that the event giving rise to the damage is where the website has activated. Finally, we've got the KitKat case, which is very interesting because regarding the acquisition of distinctive character by use, the court, in the fight between Nestlé and Cadbury, finally confirmed that this distinctive character acquired by use should take place throughout the whole European Union, which is something that could refer to several member states or even the whole Union. And it states two rules that are very important to retain. Point 81, it is possible that certain goods and services for economic operators have been grouped in several member states together in the same distribution networks for marketing strategy. In those cases, this cross-border market should be considered as the place to analyze the distinctive character, the acquisition of the distinctive character. And the same happens with geographical, cultural, or linguistic proximity between two member states. I think I will stop now because I have passed my time. In any case, I remain at your disposition for later questions, and I thank you very much for your attention.
Thank you, Judge Ulloa. Indeed, I see that the exceptions to the rule have become more numerous in the last years. I have also a question about that, but we'll leave it till the end of the session. So, Alexander, you have the floor. Thank you.